Okay, ladies and gentlemen, we start sharp at 14:40. So let me introduce our distinguished panelists. First of all, let me introduce and welcome Annemie Turtelboom, who is chair of the Audit Chamber 2 at the European Court of Auditors. By the way, Ms. Turtelboom was member of the Belgian Parliament for 7 years. And then let me introduce on my right Miroslav Čak, partner of the AGM law firm from Slovakia. On my left, I welcome Kati Cseres, Associate Professor of Law at the Amsterdam Center for European Law and Governance at Amsterdam University. And last but absolutely not least, let me introduce my colleague, Nick Iosa, who is the Director of Transparency International EU. So as you remarked in the first panel, tackled mainly and dealt mainly with the issues of rule of law and protecting the EU values. Now we will speak more about the EU funds, but as we all know, the two are very much interlinked, and we all want, I think, that it should be even more interlinked than as it is now. So my first question goes to Ms. Turtelboom, and I would like to ask you about the assessment of the conditionality regimes. How do you see to what extent they were successful based on the previous 4 years when the conditionality regulation, almost 4 years, it was accepted, and based on the last 2 years since the European Council triggered the conditionality mechanism against Hungary. So based on this experience, what are the strengths, what are the weaknesses of these conditionality regimes, and how do you assess their transparency? The floor is yours.
Well, thank you very much. And first of all, I would like to thank you for organizing this conference. We know that it needs a lot of courage to do it. And for inviting me and giving me the possibility to present our report on the rule of law. We actually published 2 reports on it because one could say, why is the European Court of Auditors making a report on the rule of law? Well, there is the conditionality regulation that links the rule of law to the European budget. It's a novelty. I think it's the only place in the world where it exists. It's in Europe. And we actually, to start on the positive side, because it's important to be balanced in life, is we have to say that the conditionality regulation is really an added value in Europe. In the sense, linking the rule of law to the budget is important that that's possible. Why? Because if you don't have a rule of law, then down the road you will have an abuse of funds, of taxpayers' money. Whether it's maybe it lasts 2 years, maybe it lasts 5 years, maybe it lasts 10 years, but you can be sure that if there is not a decent rule of law, there will be abuse of funds. That's the reason why we were, in our opinion, that we wrote about it in 2018 already, that we said we welcome it because we already talked this morning about the Article 7. There were already 2 systems in place, but there were what we called actually nuclear bombs. It's immediately trying to kick a member state out of a union for abusing funds. It's maybe there was nothing in between. So that's on the positive side. We also checked and we found the rules of the Commission compliant with the regulation and really based on a fair assessment. That's on the positive side. But we found some inconsistencies, and I think that is quite important to go ahead with it. For example, for the RRF, where you have the milestones and the targets and the super milestones, there we found that they were applied in some cases, and in other cases it was not applied. And for us it was not clear why it was applied to certain member states and not to all the member states. I have to say for the audience, we did take a look at Hungary, but not only to Hungary. Actually, we were mainly looking at the general system like it is system. So it was for us never clear in the staged approach that the Commission was using, meaning first of all the annual report on the rule of law, and then checking which member states there could be a violation of the rule of law, and then going to otherwise to all stages further, with ending only with Hungary. It was not clear for us why they ended up only with Hungary and not maybe with 4 or 5 other member states. And I think if you want to have a system on the rule of law, it's important that you apply the rule of law yourself as well in a decent way. What were the main risks that we highlighted is, first of all, and I'm not going to give my whole report, I can go further on it later on, is first of all the risk of a box ticking exercise, meaning you have a super milestone and you say you need to install an integrity body. You install the integrity body, but actually on paper it might look well. Whether it will work well, maybe you need like 2, 3, 4 years to check whether it really works well. But on paper it's easy. Paper has a lot of patience. You say tick the box, okay, integrity body, done, voila, we tick all the boxes and the money is released. Whether it works on paper or not, that remains to be seen. And this brings me then to the second risk that we highlighted, is that blocking funds is way more complicated than unblocking funds. Why? Because if you want to block certain funds in certain member states, it needs always to be based on a financial and a legal analysis. While unblocking funds can also be part of a political bargaining, because we know that we have the unanimity rule in Europe. For example, the unanimity rule exists when you want to install new own resources in Europe, or we saw it in December last year with Ukraine, that at a certain moment it has been used at that moment to unblock certain funds, in this case for Hungary. But this is something where you can end up in a cat and mouse game, where you say you block, you unblock, but you cannot do it all the time. Certainly because, and that's what I want to highlight, that blocking the funds is actually more complicated than unblocking funds. We also saw it the moment that there were, after the elections in Poland, there was actually very quickly a decision of taking some measures for Poland. So there is margin for interpretation, there is margin for inconsistency, and so I only highlight 2 of them, and then more than happy to talk about the other findings in our report, but that were actually the 2 main risks that we saw, but that you may not underestimate, because one also needs to be very prudent that you have a certain constellation of a commission at a certain moment, but the constellation is not a given if you see how the elections are going in the different member states, and therefore that's the reason why we are highlighting that to respect this conditionality regulation, also the rules need to be respected in full, for good in the good cases and in the bad cases. So I will leave it here for now. But again, I want to highlight it's a new set of tools, important in addition to the existing tools. And then maybe really to finalize is that it's not only the conditionality regulation, but you have the RRF, you have the enabling conditions. So actually the Commission introduced 3 new systems of trying to keep the member states on track.
Thank you very much, Mr. Turtleboom, and I'm sure we will speak more about the conditionality regimes. And now I would like to turn to Nika Josa, Director of Transparency International EU. And I would like to ask you, Nick, about the fate of anti-corruption directive As we know, anti-corruption directive is about harmonizing criminal offenses and legal definitions of them, such as, for example, misappropriation and trading in influence, and also extended it beyond the current regulation. So Minister Bóka kind of put the blame to the European Parliament in his speech, while the anti-corruption directive has not advanced during the Hungarian presidency. So I would like to ask your opinion. How do you see when the anti-corruption directive can be finally approved, and whether there is a danger that at the end of the day the Council will water down the Commission proposal. So please give us a short assessment of this very important and new, the first ever anti-corruption directive of the EU. Thank you.
Thank you very much, and I'd first like to extend my thanks for the invitation and organizing this event to my chapter in Hungary and to Connect Europe. I think it's a very timely debate, and I'm very pleased to be here on the panel. And before I perhaps challenge the minister's assessment on why or why not the anti-corruption directive has been stalled, I'd first maybe just like to reflect a little bit on what was said around the toolbox, because I think context is important, and particularly historical context, because now we're entering a new legislative period where, again, there will be debates on the effectiveness of the toolbox and if and why we might need new tools. And again, the EU has taken a very extended approach to try to address the rule of law deficiencies and the problems we see in the member states when it comes to anti-corruption. It really started in 2014 when the Commission came forward with what we found was a very comprehensive, country-specific assessment of the then pre-Brexit 28 member states' frameworks when it comes to anti-corruption. And as soon as it was published, it was met with such severe backlash from the member states that the Commission became very politically skittish and abandoned it. And so in response, what they did to try to address what was an absence of assessment is they tried to incorporate looking at anti-corruption within an economic lens, and they tried to incorporate it into the European semester and see what the kind of corruption might have on sort of the macroeconomic trends that they assess. But we also found at the time that it was completely insufficient exercise to really look at anti-corruption. And if you take a look at some of the early reports, I think some of the recommendations were only pertaining to 8 or 9 member states on any given annual cycle. We also had at the time the Common Provisions Regulation, which I always felt, and many of us felt, was a completely underutilized tool in what was a non-existent toolbox to address issues on financial management and the ability to spend funds if that management wasn't properly utilized, as well as the enabling conditions, which has been spoken to and which I will perhaps expand on. And then we had, of course, the toolbox, the real comprehensive toolbox where you looked at the preventative measures, such as the annual rule of law assessment, now with country-specific recommendations, but also punitive measures. The Commission doesn't call it punitive, but I suppose they call it preventative, but the conditionality regulation, I suppose, is preventative right up until you use it, and then it becomes punitive. And so we have a toolbox now of several different tools. We have infringement procedures, which have been mentioned today, which I find lengthy, case-specific. They don't touch upon systemic problems. And they never really result in a satisfactory conclusion, as unfortunately this building is testament to. We have the CPR, which I again think is hugely valuable, and I'm very pleased that actually in the last several years, particularly when it comes to Hungary, that the Commission has utilized the ability to stop release of funds until certain horizontal enabling conditions are met when it comes to fundamental rights. We have the conditionality regulation. Now, Mr. Bóka seemed to give some sort of, I would say, false impression that they have been pushing in the Council for some sort of rule of law peer review or peer mechanism. I would argue that the conditionality regulation and the use of it is a peer review exercise insofar as the Commission proposes these measures and the peers in the Council of the European Union of Hungary vote to suspend those funds. So the peers have spoken when it comes to Hungary inside the Council. And then we have the RRF. And again, there's some sort of, I say, disingenuous impression again that somehow the European Commission are imposing these super milestones on Hungary. But the super milestones are the product of an agreement, a negotiated agreement between the Commission and the member state involved, in this case Hungary. So Hungary admits that there are systemic problems when it comes to the lack of independence of the judiciary and the lack of proper anti-corruption framework. They've agreed to that, so there's no imposition. Now they just have to meet those milestones that they have recognized and agreed to. And so the path forward, and again, this is when I think we have to come and take a look at a more holistic view. I have the opinion, and I think it was spoken, that there are two camps. Perhaps it's a camp that has been born from perhaps being in Brussels too long and being slightly jaded and tired. But I don't think there are no new, I don't think that the toolbox is insufficient at this stage. I just think it's being underutilized. I would prefer that there be not that discussion that happens every 5 years when there are new rounds of politicians to have an expansion of the toolbox. You have a new college that are excited. It is a huge amount of effort politically to adopt, discuss, and utilize these tools. And I would caution against getting wrapped up in another theoretical but interesting discussion about what new tools. My point is we need to utilize the tools that are in the toolbox, and they are being underutilized. And I would take the conditionality regulation as the prime example of underutilization. Yes, I am very, very pleased and impressed that the Commission and the Council have gone through this exercise of utilizing that tool. But you don't have to wait, you know, for a member state to become completely state captured to utilize it. It is meant to proportionally address systemic, identifiable rule of law deficiencies, and I would argue that there are prime examples in the member states right now, in Slovakia, in Greece when it comes to the media, where the tool could be and should be used. And I think that there needs to be, and this is recognized, I think, in the commissioners designate responses to the questionnaires in the committees, the need to streamline these existing tools. There seems to be a disconnect between, say, the enabling conditions and the conditionality regulations. While understanding that all of them, because of, I would say, perhaps some limitations in the competence of the Union, are budget instruments. They're budget instruments because that's the legal base that they've been created on. But there's a misalignment, and I would argue that one way you could streamline things without creating new tools is just slightly adapt some of the tools. For instance, the four-pillar methodology. If we had a fifth pillar on fundamental rights, it would be much more linked to the enabling conditions on fundamental rights in the Common Provisions Regulation. And then on complementary tools like the Anti-Corruption Directive. I mean, this is going to be a very, very hugely important directive if passed appropriately. Now, there are doubts whether it will be. One is because the European Parliament has come forward with a very ambitious text, more ambitious than the already, I would argue, ambitious proposal by the Commission that has been completely blocked in the European Council. The European Council hates this directive from a very fundamental perspective, not just the Hungarian presidency. The member states hate this because they have forgotten the fact that the Treaty of Lisbon has been passed and that the issues of criminal justice are now the competence of both the co-legislators, the European Council and the European Parliament. So fundamentally, there is a cultural problem. And then there are member states that have a whole host of issues. So in many of the respects, a lot of the issues that we're dealing with, the conditionality regulation in the toolbox and the rule of law report, like preventative measures, are contained in the directive. The Commission is spending so much resources into having these country-specific recommendations on preventative measures. When it comes to asset declarations, which were mentioned earlier, lobby transparency, conflicts of interest prevention when it comes to public officials, all they have to do is make sure that the directive, in which the Parliament version has these preventative measures in place. They will tick that box and not have to put that much more effort into addressing non-binding recommendations through an annual assessment. And as far as process goes, Tineke Strik was absolutely correct. The European Parliament came forward with, I would say, the correct text of a potentially adopted directive early in the spring. The Council has also come forward with their general approach, I believe in May or June. Why hasn't it progressed? It hasn't progressed because, unfortunately, the Hungarian presidency has been dealt a hand of timing luck that has not been advantageous. The most I would say, lackluster, inconsequential presidency of any legislative mandate is the first one. Because in the first 6 months, you have a lame duck commission where they are focused on replacing the commissioners in the college. You have a new set of MEPs. I mean, the European Parliament Civil Liberties Committee, which is tasked with this, was only really constitutional and operational 6 weeks ago. So of course, there's not going to be any negotiations. So it's not really that the Parliament's delaying, is that it just hasn't constituted itself properly to enter into negotiations. And there is a truth to say that there's lack of political will to touch upon legislative issues when it comes to anti-corruption led by the Hungarian presidency as the negotiator for the Council. That's to be clear. But unfortunately, that's just the way it is. I mean, the Council presidency has had some opportunities to, yes, bring about some, I would say, lackluster rule of law dialogues. They haven't progressed, obviously, on Article 7 discussions. What they've instead have done, with the very limited power at their disposal, have used the power of the soapbox, which is what has afforded to the presidency. And so instead of, focusing on real issues and trying to engage with their colleagues, they've used the soapbox to do a range of things, including dubious trips to visit war criminals in Moscow under the auspices of a presidency which they don't represent. And so perhaps I'll leave it there, but I have more thoughts, of course, during question and answer. Thank you.
Thank you very much, Nick, for this comprehensive overview. And let me, we will certainly come back to some of your points later. I would like to hand over to Kati Cseres. Well, there has been a number of evidence that the EU funds, or a considerable part of EU funds, have been abused for undue reasons in this country and also in some other countries. But in this country, as it was already mentioned during this morning, it has been systemic and structural problem, which is very tightly connected with the rule of law problems. So my question is to you, to what extent do you think that the conditionality regimes can prevent this EU funds fraud, which is enormous, we all know, in this country, and what are the existing toolbox, as Nick said, enough, or something else needs to be included to prevent stealing of the EU's taxpayers' money? Kati.
Yes, thank you very much, and also, is this on? Yes, okay. Thank you for having me, and also to be able to contribute to this panel. It's an honor and a pleasure. Indeed, I would like to offer my own views, which might be a bit of an alternative, but I hope to convince you that this is an alternative worth looking into. Because I think we have a lot of faith, indeed, on the mechanisms of conditionality. Maybe we come later on to other weaknesses that especially constitutional lawyers have been also discussing, like there are some issues whether the Commission is not overstepping its competencies. There is an ongoing issue with the economization of the rule of law issues and a constant prioritization between economic and fiscal policies and the rule of law issues. And I think we also have to mention that indeed this, not that toolbox, but the toolbox between the nuclear option and the conditionality regulation, which very much lays also on soft law, non-binding recommendations, what other tools there might be. And I would like to indeed shift a little bit the discussion to something that I think we didn't touch upon, or not very prominently in the morning, namely also the new political guidelines of von der Leyen, President von der Leyen, to look at the rule of law issues and the toolbox through the internal market dimension. And this is where I would like to come in, indeed, how we can protect the EU budget, the funds, and especially looking at these issues from the perspective of Hungary, where basically from 2013, we have been reading each and every time, for example, in the European semesters, this half a sentence of there is a lack of competition in public procurement procedures, or there is a low level of competition. And what I have always missed in the discussions, and also whatever the Commission has done, either in the milestones or any other warning actions, is so what should happen about competition? And I think they have done a lot of work in the milestones, saying there should be an integrity of authority, there should be competition created, and the procedures more streamlined and more integral. But they have never asked one question, which is very close to the lack of competition, namely, what does the competition authority do? And whether the enforcement of competition law, which we know that if there is no competition, that's a likelihood that procedures have been rigged. that there has been collusion is one of the hardcore violations of competition law. So I have always missed that question. I have always missed basically the benchmark or the standard of effective competition law enforcement in this whole rule of law debate, but especially with regard to corruption and the EU funds. And if you allow me for a few minutes, I would also want to say a little bit more about why I think that competition law and the enforcement should be part of this rule of law discussion. I think it's a value, as we heard this morning. I should have asked the question. I think it's a shared value in the EU, but also a very strong constitutional basis in the treaty. So it's part of the legal order, and that's called undistorted competition. So free competition for me is certainly something that all the member states share. I am not aware of the fact the Hungarian government ever questioned that. And why I think it should be part of this whole, of the Commission's action plan, and let's then not call it the new toolbox, but the toolbox that exists, is because it has exclusive and direct competence. So we don't end up with all kind of issues of overstepping its competencies. It is in the hands of the Commission. It has far-reaching enforcement powers. I exaggerate a little bit, but we can have a further discussion about it. The Commission does have a legal basis to even take over cases from national authorities, from national competition authorities. It can always use its state aid law powers to look into also whether public procurement procedures have been followed, and if they haven't been followed, that might be a likelihood of state aid law. Moreover, to trigger this action by the Commission, we have judgment from the General Court of Justice, which laid down a way in a Polish case, bringing together competition law enforcement with mutual trust, sincere cooperation, and Article 19, paragraph 1, about the independence of judiciary, and saying that in a case where a national competition authority might not be functioning independently, that mutual trust can be broken, and sincere cooperation, and as we have heard, there should be actions when mutual trust is not present, and that means in that network of national competition authorities and the Commission, that the Commission can take over cases. So just to finish it off and very briefly to summarize, the Commission has a very concrete and very powerful instrument to defend the rule of law and also to protect the EU budget, which I think so far has been completely underused. Thank you.
Thank you very much. And now I'm turning to Miroslav Čak, who comes from Slovakia and head of a law firm in Slovakia. And Miroslav will speak you about the Czech and Slovak situation in terms of use of EU funds. So my question is what you have heard about the Hungarian situation during this panel. We spoke less about the Hungarian situation, but in the previous ones more. So was it surprising for you, and to what extent the Czech and Slovak situation is different? And please give us an assessment about the use of EU funds in Slovakia and in Czechia, with special regard to the public procurement system. The floor is yours.
Thank you very much. As Martin said, I'm an attorney in Slovak and Czech legal office, and we are specialized in public investments and public procurement in Czech and Slovak Republic. And this is mainly the reason why I'm sitting here, because I was told to explain what is the reality or the practical interpretation of public procurement connected to the EU funds on the ground of Czech and Slovak legal acts and legal reality. In Czech and Slovak Republic, I can say that mainly as it was said by my four speakers, the boxes are checked. Yeah, formally there are two bodies which are independent. I can say that they are led and occupied by professionals, yeah, honestly. In Slovak Republic, it's directed, or the public procurement office is directed by Mr. Kubovic. He was voted by the former government in a very focused and media-focused procedure, open procedure. And before Mr. Kubovic, there was Mr. Hlivák, who was also a professional, and he did lead the office in an open way. I can say that even the Czech competition authority is also independent. It's not linked to some government and is led professionally. And also the decisions are professional. They are reasoned. They are based on legal grounding and explanation and whatever. But I can see that in a recent time period, last year, there has been undertaken some legal steps, legal changes and amendments in the Slovak Public Procurement Act. They are undermining the transparency and the correctness of the use of, or are able to undermine the transparency of using the EU funds. As we know, the directives which are adopted by the states, they govern the public procurements mostly in the area of public works from above some thresholds which are quite high. Yeah, the threshold for public procurement of works for an open procedure are above 5 million and 5.5 million euros excluded VAT, and this means that the public works which are under this threshold might be governed by some national legal frame. And in the last year, or before the changes, the public works contracts, public procurements for works had been published. There was an obligation to publish the call for bid when the threshold was above 180,000 euros excluded VAT. Lately, to 300,000 excluded VAT. And the last amendment with the new government, which was set in Slovakia, is that you have the obligation to publish the call for bid when the forest scene price is above 800,000 euros excluded VAT, and you can object on the not formally but materially independent office when the threshold of the forest scene price is above 1.5 million euros excluded VAT. In the area of the competitors, this means that large scale of public works are not published. You don't get the information that it's even something happening, and the call for bid is published, or the obligation is to publish it only between 3 potential competitors, not officially, not published in a registrar or on a website or somewhere where you can read it and get the information. But there's one difference in EU-funded projects that when the managing authority of the RRF had seen that the government and the parliament is undertaking such an such an amendment of the Public Procurement Act that is like hiding a lot of contracts in shadow, and that a lot of contracts or even published call for bids can't be objected by the competitors when there are some conditions that are discriminatory or non-equal treatment. They cannot object to the office, as we said. There is a tick that there is an independent office, but the legislation does not give you the opportunity to make an objection against the conditions in the call. And the managing authority has undergone some like strengthening to make it more strict that the EU fund project must be published when the threshold of the foreseen price is above 360,000 excluded VAT. But still, you cannot object to the Public Procurement Office. This means, in the reality, as I said, we are like providing services also to the bidders as well as to the procurers or the public procurement bodies. This basically means that you know that there is a call for bid, but the conditions still might be discriminatory, and you cannot object officially to an office, which is a tick that, yeah, they've got an office, they've got a director which is led by, or he was chosen, he's okay, he's professional, and the people who are working with him are also independent and official, but basically the law is changed so that you cannot object. Yeah, so formal change that is very competitive, or is you can discuss if this is or is not against the rule of law, but basically it's in accordance with the EU directives. Yeah, and the second very important change in the legal act of public procurement in Slovak Republic is that and to comparison with Czech Republic, such threshold don't exist in Czech Republic. Yeah, the Czech thresholds are when you're above in the works. I will focus on the works because this is the most money goes to public works, or the biggest money. So in Czech Republic you have to publish, and you are allowed to make an objection when there's the threshold. Maybe it's 6 million crowns. It's about 200 and something thousand euro excluded VAT. Yeah, so when you compare it to the 800,000 and 1.5 million, that means that the transparency of spending the public money it's uncomparable to Czech Republic because of the last amendment of the Public Procurement Act. And what's very interesting, and it's also a kind of thinking that yes, this is everything all right, but materially, when you think about it, that it raises some questions about the independency. The Public Procurement Act has been changed that has been used the oldest strategy when you want to conquer some office, make a reorganization, do some changes that you want to split it or to make an acquisition or merge it with another office. In Slovak Republic, there has been a legal change that in the Public Procurement Act, there has been set a special deputy of the director. Yeah, the Public Procurement Office is led by a director. Before the change, he was he chose his deputies. He was responsible. He proposed it to the deputies to government, and the government set the deputies based on the proposal of the director of the Public Procurement Office. The last change in the public procurement said that there is a new kind of deputy who is responsible for making decision on objections concerning the strategic investitions or investments, and the strategic investments are chosen and decided by the government. So the government says this highway is strategic investment. When a company or a competitor wants to object, he gives an objection. It's above 1.5 million, maybe 10, 20 million project. He gives an objection, and this objection is not decided by the typical or the standard employees of the Public Procurement Office, but it is decided by a special deputy with the special people, special employees who are under this deputy, and this deputy is set on the proposal of Minister of Transport and set by the government. This means that this deputy is not independent. Yeah, he's not chosen by professionals. He's chosen by politics.
Okay, thank you very much, Miroslav. You mentioned several times the ticking the box exercises, and I would like to pursue the conversation on this topic. Mr. Turtelbaum mentioned it first, that it's a major challenge of the conditionality regimes, that it might be just ticking the box exercises. And I think if we look at the Hungarian case, for example, it's very much striking that there are a number of occasions where the laws formally are in line with the EU norms and the EU regulations, but nevertheless it does not work in the reality. The most obvious example of it is the public procurement system, where the laws are in line, but still public procurement in Hungary has been a hotbed of corruption, and as we have just heard, it is in less extent, although, but it might be the case in other countries as well. So my question is first to you, Anemi, and then I would like the rest of the panel to jump in. The question is how to overcome this huge challenge that the conditionality regulation should not be just a piece of paper to tick the box, but it could somehow substantially change I almost said that the regime, at least in the sense that the rule of law is established and the anti-corruption measures are really effective, not only on paper but also in reality. So what you mentioned at the beginning about the ticking the box exercises, how in your opinion the EU institution can overcome this challenge, if anyhow?
Mm-hmm. Well, I think it's quite crucial because we don't want that conditionality regulation, who's as such a good instrument and a good additional instrument, that it is just not working properly, because then it becomes something. Because why is it so important that it's well implemented? Because if you are a country that's a little bit borderline, and you see that another country who is like at the bad side of the coin gets away with it, via a ticking the box exercise, why would you then try to behave? Why would you do? Then you say, okay, they can punish me. I will also do a box ticking exercise. I will change some laws on paper. Full stop, it's done. They unblock my funds. And I know that blocking the funds, it's way more complicated than unblocking the funds. Okay, looking forward, because it's always important to look to the future. That's the reason why we also gave some recommendations. And one of our recommendations was that there should be a really good monitoring of what happened till now and the measures that are implemented, so that you are not only doing checking what happens now, but that also the Commission is following further down the road. It was, I think, our third recommendation, that the monitoring the impact of the rule of law related measures, so that you also check whether what it gives further down the road, and that you also build up a file. Second, was another recommendation is, and it's not very sexy what I'm going to say, but nevertheless, there needs to be more administrative capacity. When we started with our audit on the rule of law, we saw that actually 6 people were working on it. 6 for 27 member states. Okay. Now one could say, I don't do politics, I'm the European Court of Auditors, so I'm asking a question. Why did they only start with 1 or 2 member states? It could be maybe the case that otherwise they could not find a majority among the other member states to vote, because if you start immediately with 5, 6 member states, maybe you no longer find the majority at the council to vote it. I'm not sure about it, but it's a question that I can ask myself. But that is to me crucial. When it comes to public procurement, because we also have another report on public procurement where we see a trend. And now I'm going a bit beyond Hungary because we are, of course, checking the 27 member states. There we see actually a very worrying trend in the sense that in all the member states, for example, we know that approximately 14% of the GDP in the EU is spent on public procurement. And what have we seen? That actually 14–15% of the public procurements is actually a direct giving the file to one private company, so that there is actually no longer an open competition. And that is, if we see the trend between 2011 and 2021, it's going in the worst direction. And if I then take the figures for Hungary, and I'm just looking at my file, there was the amount of items with no call dropped from 30% in 2011 to 10% in 2021. From 30% to 10%. Okay, quite a worrying trend. Now, to be fair, it was not only the case in Hungary, it was all over the place, the case. But okay, here it was maybe still a bit worse. And then the amount of calls which received only 1 bid, so meaning it's one private company who applies for it, and then the government has 2 options. Either they decline or they accept the offer. Now, we also know that 1 bid is from time to time that the private companies within a certain region or within a certain country align themselves by saying, now it's your turn. It's not always the case, not always, but it could be the case, could be the case. And there we saw that remains above 20% rates, which is actually quite high, and it increased from 30 to over 40%. So what I want to say, no call too high, 1 bid also too high. Again, not only the case in Hungary, but so it means we also had a whole set of recommendations. And I have to say that the council really accepted all our recommendations and said, okay, the change in the public procurement law in 2014 needs to be adapted. And it's true, it's crucial. We cannot have a Draghi report on the functioning of the internal market and then closing our eyes for public procurement. We may not forget that one of the big achievements of Europe was the rights of consumers and passengers, was Erasmus, but also public procurement, because the game of public procurement was that it would decrease the price for the consumers and that it would make certain products more affordable with asking actually less money for the taxpayers and the citizens. So having said that, first, on the one hand, on the conditionality regulation, please, and I fully agree with you, it's a good tool, but it needs to be implemented, and it needs to be properly implemented. And if you don't have these tools, well, I have a history in politics. I was also 8 years in the government in Belgium, and we also said, when you have a good idea, and a bad implementation doesn't lead to anything. A bad idea, the good implementation, you can give it a chance. And the ideal world is a good idea with a good implementation. Here I would say, we have a good idea, the implementation, room for improvement.
Thank you. I would like to ask the opinion of the other panelists about that. So, Mr. Turtlebaum said that basically implementation is crucial. Monitoring, increasing administrative capacity. Is there anything else that you would like to add? Are you agree with that
I fully agree, and I'm often the one that also echoes the very non-sexy recommendation of resources. You know, if you have an authority, if you have an institution, you have a body tasked with a particular mandate to fight corruption or instill the rule of law, you need to resource them properly. The Commission's example, but you know, you have countless examples, even at an EU level, where enforcement bodies aren't properly tasked or resourced with the tasks that they've been given. I would say the most recent example would be the European Public Prosecutor's Office, who started a very ambitious mandate, very ambitiously, without the proper resources. And ourselves and others have been fighting to increase that budget in the preceding years since it's been established. And yes, I do think that it is a good tool, and the implementation is a problem. One way I think that could be improved without tweaking the substance of the regulation is to, and it was mentioned earlier by some of the panelists, including Martina, is the transparency of the process. The transparency of the process is a real problem, particularly when it is. Yes, it's not a political process, but it has political implications. It has political considerations, and it's subject to being politicized, as we saw this morning through Minister Bóka's intervention. And as much as the Commission, you know, rails and justifies that this is an objective assessment, unless there's the accompanying transparency to observe that assessment, to have externals such as civil society or journalists or other member states or parliamentarians consider the actual substance of the assessment, then that politicization will be inevitable. And it would also, I think, instill a little bit more credibility in the process. I know that Vice President Jourová, and I know her team has been very critical of our very critical assessments of the release of the funds last December on what we had, I would say, rightly determined was considerations of a release through a blackmailing exercise by Prime Minister Orbán while holding, you know, crucial geopolitical instruments at hostage, was somehow subject to an objective assessment. Maybe, but there's no transparency for ourselves or others to say, was it blackmail or was it an actual objective assessment that that milestone was fulfilled and that 20 billion can be released? And again, so without that transparency, the credibility of the process will be injured, the politicization will be allowed to be exploited, again, as we saw this morning. And I think that the final, and again, I understand that there are political considerations in activating this because it will come to a democratic vote. It will come through a democratic vote in the Council. And I know, having worked very closely, I mean, I was involved with the advocacy of creating the conditionality regulation and trying to get the Commission to the first time use it. And I know that this was weighed heavily on the minds of the commissioners and the cabinet members on Hungary. But think about other member states. Did they have the votes in Council? They were vote counts. Do they have the votes? And again, I think that in one way, and you can see it having, again, I worked in the European Parliament for many years before joining TI 10 years ago. You always see politics driving an assessment or an understanding of rule of law where there would be non-binding rule of law resolutions in the European Parliament on Malta, and all of the socialists would circle the wagon and say, that's unfair, it's not true. You had it with Fidesz when they were part of the EPP family. You had the liberals circling the wagons and voting against resolutions when it came to then Prime Minister Babiš. One way to, I would say, try to break down that and perhaps build support to get a qualified majority is the transparency. Here is the assessment of why we think there are real substantial problems when it comes to rule of law in Slovakia, why there's real problems when it comes to rule of law in Greece when it comes to media freedom. And with that, I think it can help build the political will, build the political momentum to perhaps tackle what is inevitably going to be a tough road to build that political majority.
Before I ask Kati and Miroslava, I should say that, of course, we invited the Commission experts to this conference as well, but due to the transition process, they declined. So, because there are a number of allegations here which would need a reflection from the Commission, but as I said, they declined. Apart from Vice President Jourová, as you saw. So okay. So then. Kati, I think you wanted to add something.
Yes, I think this is maybe the best question today, how to overcome the ticking box exercise. To start with, I think the Commission really likes ticking boxes. That's one problem. Another problem is that many of these issues, and we talk about the Commission, but the Commission is not one homogeneous organization, but there are DGs. There are various DGs, and often they like to be isolated and have their own agenda and priorities. So one of the things that I am very curious to see in the coming years, once we have a new Commission, whether this can be overcome or overstepped, and I'm not sure. Even if you convince whatever is going to be DG Justice about the relevance of media freedom and pluralism, I think they are convinced. Who is going to step up if it's a state aid law case from DG Competition or DG Budget? I think that, so I think how the Commission is now ticking the box exercise is something they really like. Now, we talked about why is Hungary special. I think Hungary should be special to teach the Commission and everyone who is interested in this topic that ticking the boxes doesn't work. I don't have an answer to how overcome it, but I have some kind of gut feeling what should be the way forward. And maybe that's not the right term to call it, but some kind of matrix thinking where we indeed try to overcome these isolated and monolithic way of thinking about issues, because you look at, and let's go back to media pluralism, you look at concrete cases, you don't just see one part of the law or politics, but you see many of them. You see public procurement, you see state advertising, the new Media Freedom Act, you see media freedom, media pluralism with different competencies on the EU, on the member state side. And let's face it, I hope I will be still loved after this talk, but the Hungarian government is extremely good in creatively going around this ticking box exercise. And I truly believe we will not achieve anything if we are not going to engage in the same way in this creative exercise. And if I may add something, you raised the question about independence of authorities. I always give the example of, I am more familiar with competition authorities where there is also a requirement for being independent. On paper, the Hungarian Competition Authority is independent. On paper, the Dutch Competition Authority is much less independent because it's only its board which is independent. All the rest is part of the Ministry of Economic Affairs. De facto, I leave it to you to decide. But these are the issues that if you don't get to the bottom of it, it will remain a ticking box exercise.
Okay, thank you first, Anemi, and then Miroslav.
I wanted to add something on the transparency, and something that was quite, I wanted to add actually two examples. First of all, what was very surprising for us in our audit, that we had to deal with Commissioner Hahn and not with Commissioner Reinders or Commissioner Jourová. Okay, fine for us not a problem because we can make our analysis. But the moment that you have three commissioners responsible for implementing the conditionality regulation, the enabling conditions, and the SWAT, okay, you understand my point. I think it's already a bit embedded in the system that it's not a lean procedure. If you have then on top of that 6, 7 civil servants working on it, that doesn't work. That's my first point I wanted to add. Second, on the transparency, I fully agree with you, but also with the other mechanisms. And I give an example, we write it in our report. The Commission stops the cooperation and verification mechanism for Bulgaria and Romania because they said, okay, apparently everything goes well, though they write that not everything is going well, but they don't open they don't open the conditionality regulation on it. So we said, but for a citizen, how is possible that Schengen, yes, no, Euro, yes, no, conditionality regulation, no, CVM, we stop. So what is it? Is it then fine or is it not fine? I think so the transparency also not, because we also then saw in our report that staged approach, starting from the 27 member states and breaking down all the time, it's not clear on which criteria it's happening. And I think it's undermining, once again, a good system. It's undermining if you divide too much the powers within the Commission. It's undermining when you are not transparent for the one for one of, or for the 3 new mechanisms, and it's for sure undermining if you then don't make the link with the other existing mechanisms that all of a sudden they are coming to an end.
Thank you. Maybe I will add to this speech about ticking the boxes. We also in Slovakia recently had some doubts and issues about rule of law and about reimbursing some tranches from the UE funds or the RRF. I'm not sure what was what money, but it was from EU funds. And there was the danger that it won't be financed, that it won't be sent the money to Slovak budget. But the ticking box exercise did take place, and the money came, or some reimbursement, which was suspended. Was definitely paid by the EU budget, and as you can see, that the ticking box works, and our Prime Minister is doing propaganda speeches in Russia 1, and this is very interesting how this might work. On one hand, the EU measures and EU values are ticked in the box, this is okay. And on the other hand, the leader of the country is doing propaganda in Russian television. Yeah.
Thank you. I think we are all aware of this huge challenge, how to overcome the ticking the box exercises. And at this point of time, I would like to open the floor, and I would like to ask you to ask questions or make comments. But if there are comments, just very short comments, please, because of the lack of time. So I'm asking the audience if you have questions. I think Ferenc has a question.
Thank you very much. Just a quick comment regarding the intersection of competition law and public procurement markets. I think
I can hardly hear you, so please speak up. Yeah.
Okay. Can you hear me? It is one thing to establish rules and regulations and competition offices of public procurement authority and ticking the box, but it's another question to examine markets as such. Like, for example, in Hungary, certain markets liable to public procurement are very concentrated markets with a small number of players. I should say oligopolistic markets in the best of cases, or monopolistic by very nature. And so no matter how hard you try to enforce relevant regulations, the newcomers cannot enter the market because they cannot even meet eligibility criteria. And that's the problem. And that situation has been created by government intervention over the years. That's the name of the game.
Thanks. Koti?
I can be very short. I completely agree with you. So if it wasn't, and I apologize if it wasn't clear, my point was the Commission should have asked questions exactly about this point. What does the competition authority do to make sure that these markets don't get concentrated and that there is working competition in public procurement markets and in sectors where this is happening?
Okay, Esther?
Kasi, thank you. I fully agree with that. Competition law should be much more exhausted, also in this sense, from this perspective. But another idea could be maybe consumer protection law, because there are all these billboard campaigns in Hungary where there are like lies on the billboards. And I already suggested at one forum that we should, but why is not under the consumer protection if an advertisement lies like for a product? Let's say that this product cures everything, whatever. Then it's okay to go under the consumer protection law. But if a Hungarian government says it's a government information that Brussels will bring in migrants to Hungary, and you know, like this type of lies, or even the statistics lies, why it cannot go under consumer protection? These billboards are in the streets, everybody can see them, there is no protection against them, regardless of the age of whoever is walking in the streets.
Can I quickly? Yeah, so you are lucky because I have a double specialization in consumer law and competition law. But I agree with you, and I have been also working on how to bring some of the issues through consumer law. There is one issue I think that you will agree with. At the moment that you want to enforce consumer law, you will be enforcing directives which are implemented in Hungary, and you will end up with consumer authorities, which are now under the ministries in Hungary, and I think we can forget that anything will happen. So it has to be a different way. I'm not saying that you cannot mobilize laws either through courts or authorities, but I would say if there is a way to use the Commission, who has the public power, who has the obligation to go after, and I think with the billboards we can also ask questions about state advertising and you know how those resources have been allocated. It's just about enforcement, which one, and it's just simply more powerful.
Oh yeah, there are two more questions. Three more questions, and then we will wrap up. Okay, so we collect the three questions one after the other. So please, Julia.
Thank you. I would like to ask Annemie, how are you now with resources for 27 countries, and what would be the good number of people, professionals, for you to work professionally?
Thank you. Next question, András, and then Judith, and then we.
Thank you. I'm András Lukács from the Clean Air Action Group, and well, it seems that corruption is partly embedded in the system of EU funding. I can tell you I could tell you several examples. Just one, which relates to competition. A large part of EU funding is distributed practically as discretionary funding. So the companies have to apply for funding, and then the state decides, the government decides who receives the funding. So this is a hotbed of corruption, and it also distorts the market. And even it is in the EU rules, one of the indicators is how many companies received EU funding. I think this is an indicator of how much the market is distorted, how much the market is destroyed, but not of the success of EU funding. So what do you think about this? And I could tell you many other examples too. Thank you.
Okay, thank you. And Judith, last question.
I'm Judith Zegnál. I work for Transparency International Hungary. A question to Annemie and maybe all of the other panelists. The Commission has floated the idea that the next EU budget should consist of big national envelopes, and then the allocation would be styled in an RRF sort of way. Allocations linked to benchmarks. Would it help to improve transparency, or rather the opposite?
Okay, thank you for the question. So I suggest perhaps that Annemie takes at least two of the three questions,
yeah.
And then all the other panelists have also time to reflect if they want.
Yeah, first of all, thank you for the questions. If you ask me what would a good amount of civil servants, that's hard for me to say because I'm not operationally working at European Commission, but what is clearly is that 6 is not enough for 27 member states. Should it be 50? Should it be 25? Should it be 27? I cannot say it, but it's clearly not enough to do it with 6. Second, on your question on the RRF as the blueprint for the new future model. I have to say, as a European Court of Auditors, and then I'm going to the core business, financial audits, I don't buy it. And I can give you 20 arguments. I will only give you 3 arguments. First of all, it will not increase the transparency. Because the Commission works with 2 layers. They say, we give the money to the member states, and we make an agreement on the milestones and the targets. And then the second layer is the member states, and they are actually responsible for controlling the budget. Now you have to tell me, if you give me money and then I have to control myself to say whether I did not drink too much coffees with it, I'm not going to do it. I'm not going to do it. Why would I? I don't have an incentive to do it. It's like it would almost be a bit masochistic to do it so to a member state. So the control system will fail. That is for me crystal clear. Secondly, only after the European Parliament in the RRF amended the regulation by saying that the 100 largest beneficiaries should be public. Only the 100 largest one. Only the 100 largest one. Okay. Do you think that the 102nd one, that would be then totally fine? That don't we have the right to know? Because what is the main problem is the normal budget is controlled on a cost-based system, meaning you need to introduce your costs, and I can control whether you if you wanted to build a windmill, whether you built a windmill, what was the price, and so on and so on. This is now a finances not linked to cost model, meaning you have milestones and targets. If you fulfill them, you receive the money. But again, following the money is way more complicated. And we all know that to fight against corruption, you need to be able to follow the money. You need to be able to do it. If you cannot follow the money, further down the road, there will be some problems. And third argument is, the Commission always says, but the previous model is too complicated and the member states cannot absorb the money. Now, we made a report where we saw that the absorption of the money, of the RRF money, based on milestones and targets, is also very slow. So that argument is actually not working. And also the Commission said it will be more a simplification, and it is not more a simplification. So for me, honestly, it will decrease the transparency. There are more control and accountability gaps, and it's not simpler, and it's not better for the absorption. So honestly, I don't see the benefit at this moment. And this is just our professional judgment based on facts and figures and of many reports that we made on the RRF. And then I don't want to dare to say that, of course, the dynamics in certain countries may differ.
Nick.
Maybe just to echo what was just said, I too, if you look at it from protection of the EU's financial interest and to ensure that there's sound financial management of EU funds, that's not the model we want. That's not the model that's going to prevent fraud. Yes, it's going to be easier for the Commission, but it will lead to problems. I would suggest rather 2 things. One is to perhaps expand the thinking around the enabling conditions within the Common Provision Regulation, which does have accompanying financial regulations and financial management systems in place and proper auditing systems that may not be utilized all the time, but under shared management you have to work with what you do. But also what was mentioned was the transparency of the final beneficiaries, beneficial ownership registries that aren't operational or aren't working, information that just isn't available to assess whether that public money is being spent free from corruption, free from conflicts of interest. I know there was a Guardian piece just yesterday that revealed that 3 billion of EU farming subsidies went to a series of billionaires, including our old friend, then Prime Minister Babiš, who was also subject to a conflicts of interest investigation several years ago that found that he was receiving subsidies in violation of the financial regulations, Article 61, conflicts of interest. So I think, yeah, more again, I'm a bit of a broken record here, but yeah, more transparency and using existing models that I think would achieve similar means without replicating what I think is a flawed and funding model that will ultimately lead to more misuse of EU funds.
I didn't really understand the question, so maybe you can decide. We give the floor to Miroslav, and then you decide whether we have time.
My point of view to your question about the consumer protection, I think that there is no way how to protect from the information which are on billboards paid by politicians, because it's not they are not providing services basically. Yeah, therefore, when there's not fulfilled the definition of a service, and on the other hand, a definition of a consumer, you cannot make a penalty, or you cannot react on it. Yeah, the billboard is about some political information, and therefore is not covered by the consumer right protection. And to the AML. I can give an example of how it works in Slovakia, and from my point of view and from my experiences, the AML is it's fine that you have got the information who is the final beneficiary, but in the reality, I basically don't care who's the final beneficiary when the competition and the procurement and the final efficiency is in accordance, when it's okay and sound. Yeah, I don't care that the Babiš is the final beneficiary of some holding or a company, when concluding the contract or the coming for a grant or granting a money is in accordance with law, with all the regulations, and when the price is correct and is financially or economically efficient. Yeah, when you compare it, for example, in Slovakia, the AML Act had set up a register of final beneficiaries, and the process is so complicated, time-consuming and money-consuming, that basically this procedure set by the law costs the companies, when you aggregate it, millions of euros per year. Yeah, you have to, when you are a company and you get yearly more than 200,000 euro from public money, you need to be incorporated in the AML registrar, and you have to pay an attorney or a notary who is responsible for the incorporation. He must do a legal analysis of your structure of the holders or shareholders, and the attorney is a guarantor. He gives guarantee that the informations are correct. So the attorney has got to pay special insurance, and these incorporations cost from, in the easiest companies, from 300 euros to thousands of euros in companies which are national and foreign, and you have to do translations and pay for the translations. So it's when you aggregate the money, which is yearly paid, you are above millions. Yeah? And you have to do this verification on a yearly basis. Yeah? That's from my point of view, it's the benefits from knowing who's behind the company. You have to compare it to the price and to the effort which led to this.
Only 2 seconds.
2 seconds.
And then we need to wrap up.
Because yes, I understand why you in your position wouldn't necessarily care whether Andris Babiš had ownership over companies that were receiving vast funds of EU subsidies, because you have a job to do, and you have to make sure that that registration is in adherence to the rules applicable to that job, which is mostly around procurement and AML. But we care because we want to make sure that Mr. Babiš is adherence to other laws that fall outside your remit, such as making sure that that acquisition and that ownership of the subsidies is free from conflicts of interest, which was what he was found to be guilty of under the financial regulation, which you wouldn't have to deal with because it's not within your professional remit. So I would argue that yes, for your purposes, it perhaps doesn't matter who owns it. But if you're looking to make sure that funds are spent properly within the rules when it comes to anti-fraud and anti-corruption, you need to have that information.
Thank you very much. And at this point, we have to wrap up. I would like to thank again to Anami Turtelbaum, Miroslav Čák, Kati Cseres, and Nika Jósa to come and share their very valuable insight. I thank to you the attention. And now we will have just a technical break, I would say so, because we will start the next panel at 4:05 sharp because of the shortage of time. So thank you again.